Welcome everyone to the Changes for Casuals webinar. We're of course very excited to have you join us today for this special event to celebrate Victorian Law Week, an important annual event. As we start, I would like to acknowledge the Wurundjeri people who are the traditional custodians of the land that we are presenting from today. I would also like to pay respect to the elders past, present and emerging of the Kulin Nations and extend that respect to other First Nations community members present today. So my name is Zana, by the way, and I'm the Executive Director of JobWatch, and co-presenting with me today is one of JobWatch's senior lawyers, Eloise Williams. This webinar has been made possible by the financial support of the Victoria Law Foundation, and we would like to acknowledge this support because it gives us the opportunity to talk about employment rights for casual workers in the context of the new changes that have occurred this year. They're new and they're significant, and this is why we wanted to create the opportunity to share this information with you. After all, casual work accounts for an increasingly large proportion of the workforce. The stats are a bit difficult to pinpoint, but roughly 20% of the workforce is a casual workforce. And remember, of course, that women are often employed on a casual basis. So it's really important that we talk about this issue. Okay, so a bit of housekeeping. So after this main presentation, we'll answer all the questions that you have actually submitted to us before today. So we will attend to that. Also, during the presentation, you have the opportunity to drop in further questions into the Q&A function at any time during the presentation. And I urge you please to do that, because as we're going through it, things will come to mind. We have some time set aside at the end to answer these questions. Now look, there's a chance that during this presentation we touch upon sensitive topics. There may be trigger points for you. This could include things like bullying or some form of discrimination that you may be experiencing. Just a reminder to you that in those circumstances, if you need to have a brief break, we understand. Also, please don't forget that you can contact JobWatch and we'll be more than happy to assist you in the best way possible. In terms of additional emotional and mental support, don't forget your GP. Hopefully you have a good relationship there. Lifeline, Beyond Blue, and if your employer offers an employee assistance program, an EAP, look into that please. A lot of them do, especially during COVID. We found that a lot of employers made this service available to employees. Please look that up and you can contact them as well. Now this is a Microsoft Teams live event, so even though you can see and hear us, we cannot see and hear you. You can interact through the Q&A function though, and we have our wonderful comms manager Amanda driving the presentation, and both Al and I are very grateful that she is in the background helping us. But remember, she's here to help you as well with any technical questions or issues that you may have. We've also decided that it would be wonderful to have a closed captioning available on this webinar, and it's auto-generated, so please understand if there are a few misspellings along the way. If at any point it doesn't make sense, please make a note in the Q&A function and we'll obviously try and do our best and clarify that for you. I believe there's also an option for auto-translation in 6 different languages, and we're really pleased to be able to provide this: Arabic, Chinese, Hindi, Portuguese, Spanish and Urdu. Okay, the big disclaimer, always before a presentation of this nature, what we are discussing here today is general legal information. It's an overview, so we want you to have to be thinking about how this affects you and to give you some insight, but it's not legal advice. We always highly recommend that before you commence any proceedings or take any action that you speak to a lawyer about the situation. And remember, for any further information as well, detailing something that we've discussed today, please call JobWatch. Now, good news again that this webinar is recorded. So once the recording is uploaded to our website, we encourage you to share this information with your family, your friends, as well as your work colleagues. Okay. Before we get into the content, which is quite substantial, I do want to tell you about JobWatch. And this is really important because we're hoping that you and your friends and family can then contact JobWatch with any further queries that you may have. So for those of you who don't know us, JobWatch is Victoria's only specialist employment law community legal centre. Now, we are funded by the government, both federal and state, and philanthropic bodies, and we are funded to deliver legal assistance free of charge to people who wouldn't ordinarily be able to afford legal help. And this is really important. This is why this work that we do is rewarding and why it's important, because we can provide this service to people who usually cannot access such a service. Now remember, although we're funded by the government, we are not the government. We are independent, and we pride ourselves on that as well. So JobWatch is unique amongst community legal centres because instead of handling all manner of legal matters, we specialise in one field, employment law. You can say basically that we live and breathe it. And we do this through a number of services: our telephone information service known as the TIS, our legal practice, and of course our education and advocacy programs for the rights of workers. So remember that the telephone information service, which you can pick up the line at any time, is a free and confidential service, and it's available to Victorian, Queensland and Tasmanian workers. You'll be interested to know that every year we assist more than 12,000 people with their questions about their workplace rights. So through the TIS, we are able to provide the initial legal information that may be relevant to your needs. We like to call it tailored assistance. So we basically listen to your particular situation and we provide you with a range of legal options so that you can then assess what you need to do in moving forward. So for instance, if you were to call the TIS because you're being underpaid, our telephone consultant would tell you the different options available to recover your money. Additionally, our consultants are there to consider all the other legal issues that may emerge, legal issues that you may not have thought of. And we basically extract that information and then provide you with legal options that may be available on those issues as well. Okay, our legal practice is available for Victorian workers, and we try and support the most vulnerable people that call our TIS first, and then the legal practice basically determines issues of public interest, issues that relate to the most vulnerable workers, and we provide them with advice and legal representation. That could be as straightforward as writing a letter to an employer on your behalf, or right to the completion of your matter by representing you in court and running a trial. This, of course, always depends on the individual case and the individual needs of the person. In addition to that, we are particularly interested in assisting our most vulnerable cohorts of workers. So, for example, we are particularly engaged in helping those impacted by COVID-19. We also are very interested in assisting dismissed workers and also those impacted by family violence. International students are a very vulnerable cohort that we are pleased to say we assist on a regular basis. So in the context of today's presentation, I hope that you get to realise how valuable community legal education is. That is a really big part and valued component of the service that we provide. So basically, having finished this presentation, if you think that we could be assistance to you, to your workplace or to others that you may know, please reach out to us and basically ask that we assist you in delivering such a service. You will find the contact details on the screen that Amanda has placed there for you. Okay. Changes. What are the changes to the casual arrangements? So last year, you may have been aware of some discussion around changes to casual circumstances. And of course, March this year was about the government's proposed amendments to Australia's employment laws. The Fair Work Amendment, supporting Australia's Job and Economic Recovery Bill, as it was known, was initially proposed and did include a range of workplace changes. However, the only changes that were passed on the 26th of March were in relation to casual work, and they came into effect on the 27th of March. And of course, that's why we're here to talk to you about those changes. Okay, so what is casual employment? When we think of casual employment, certain circumstances come to mind. You may think that you actually know what casual employment is, but it's not as straightforward as you think, and that's why it's really worth going over it, number one, to remind you of what it looks like and also introduce the changes to you. So unlike permanent, I use the word permanent, ongoing work, where a person's hours or shifts are generally set. They are set. They are set hours and shifts. Casual work is usually characterised by its flexibility, meaning that they're not set in stone. And basically, traditionally, casual workers are employed on an as-needs basis. There is no guarantee of the hours of the shifts or work. So that is really an important difference. Okay, the other thing is essentially casuals are not obligated to accept any of the shifts offered to them. That's really an important distinction. But I really want to raise a note of caution here. So while casuals are not obligated to accept any of the shifts, in the JobWatch experience, we have found that potentially a refusal of a shift may actually mean or may translate to no further shifts, meaning no further work. So I want to raise that with you so that you understand your workplace environment. What is the culture like? What does it mean to refuse a shift? What will that mean to you? And I also want to raise the issue of communication with you, not only in the sphere of this casual presentation, but in workplace issues generally. Your ability to communicate well with your employer and your employer to communicate well with you is essential to a good working relationship. And by that I mean, if you were to refuse a casual shift, by all means discuss this with your employer, explain the circumstances so that it doesn't necessarily translate into no further shifts for you. Okay, casual workers only get paid for the hours they work. So they don't get paid annual leave, personal sick leave, and And also casual workers are only entitled to a 25% casual loading, which basically means that as a casual, acknowledging that you don't get certain entitlements, that you get paid more. You get 25% more than the base rate applicable to part-time or permanent part-time and permanent full-time workers. Casual workers don't get notice periods or redundancy pay at the end of their employment. Conversely, they don't owe notice. So therefore, if they want to finish up their employment, they don't have to provide notice. So these are important considerations as well. So whilst casual work can suit some people who want a higher hourly rate and are in a position where certainty of employment is not their primary concern, it doesn't suit everybody. So for example, it may suit a working woman who wants to turn down shifts during school holidays. If in fact, as a working mother, you may have increased caring responsibilities. Conversely, you may accept more shifts during school term when kids obviously return to school. So you can see that the flexibility and the extra hourly rate can be extremely beneficial, but with, of course, that comes the fact that you don't get the other entitlements. So one of the big changes to the law for casual workers is that now there is actually a statutory definition of a casual worker. Surprising as it may seem, for all this time there has been no formal definition of a casual worker, and now we have that. And so it's important that you know what that definition looks like and the complications that may flow from that. So before the formal definition, whether a worker was a permanent ongoing employee or a casual worker was determined by the courts, weighing up various factors that had developed over time, developed on a case-by-case basis over time. So, crucially, the courts would look at the nature of the employment over the entire period of the engagement. The court would often be addressing whether the person was employed on a regular and systematic basis with a reasonable expectation of ongoing work, often meaning that they may in fact be a permanent employee, or be looking at whether a person was offered sporadic work, could turn work down if they wanted, or were paid a casual loading and not given annual leave, meaning they're more likely to be a casual worker. So that's what they had to grapple with. So this way of assessing the classification of employee made it difficult to know with any great certainty for any employee whether in fact they were a casual or permanent worker. They look more like a casual worker during some periods, so sometimes they may look like the casual worker, and then other times it looked like they may be more of a permanent worker because things were starting to be set up on a permanent basis. So this really matters. Whether you're a casual or permanent worker really matters, because casual workers and permanent workers have a different set of entitlements and they have different obligations to their employer. So now we have a situation where the legislators have stepped up. They have changed the way that courts determine casual employment, and this is where I suppose the whole change comes into effect. So whilst the new statutory definition follows a lot of the courts previously used factors in weighing up casual employment, the key difference now is whether now will depend on strictly the moment of employment, the moment of offer and acceptance. This is the key difference now. The classification will not change after that moment of offer and acceptance of employment, until or unless there is a new offer of employment. Okay, so this means that the court can no longer look at the nature of the employment relationship as it develops over time to determine whether someone is a casual worker. It all basically is determined at the commencement of employment. So let's have a look at this new definition. Does it help us? Does it help us to really understand what a casual worker may look like? So this definition can be found in the Fair Work Act of 2009, which of course is our principal source of workplace rights in Australia. And more specifically, we'll be looking at section 15A. I have to tell you the word for word definition of this because it's important that you know it, and also you will automatically see that there are some difficulties that emerge as a consequence of this definition. But someone is a casual employee if they are offered a job that does not include a firm advance commitment that the work will continue indefinitely with an agreed pattern of work, and they accept this offer, and from that point they become an employee. Now, the law also gives strict guidance to the courts in determining whether there was a firm advance commitment, because you're probably wondering, what does this mean, a firm advance commitment at the start of the employer-employee relationship? So this is what the courts must only look at. So these are the things that the courts can only look at. Whether the employer can elect to offer work, and whether the person can elect to accept or reject the work. Whether the person will work only as required according to the needs of the employer, and whether the employment is described as casual employment. And finally, whether the person will be entitled to a casual loading or a specific rate of pay for the casual employees under the terms of the offer. So the new state of affairs for casual employment means that the moment of offer and acceptance, that moment is going to determine whether you are a casual worker or not the subsequent nature of the employment after that moment. So immediately, I think you can see the problems with this. We've all been grappling with it, and of course, the problems and clarity will differ over the period of time when you're investigating whether you're a casual employee, because things will be determined differently on a case-by-case basis. So as it stands, it appears that this could result in employers establishing, at the moment of offering a worker a job, a casual working arrangement, but then after that moment of acceptance, a worker could then be expected to work in ways that looks more like a permanent worker, but without the benefits of annual leave and paid sick leave entitlements. So Al is going to discuss these changes in greater depth with you later, but I just wanted to let you know what it may look like. There's also a really interesting question about whether this will result in more permanent workers if employers don't end up putting in the work at the beginning of the employment relationship to make it clear that the work is in fact casual. So it's going to be really interesting how this all pans out. So these issues we expect will be litigated. As a consequence of litigation, determinations will be made and hopefully guide us better along this journey. But it's an interesting space to watch, and I urge you to ask any questions along the way when you're uncertain. And now may I introduce our senior lawyer, Al, to explain some of the other changes.
put myself conveniently on mute. Sorry, people. Thank you, Zana, for taking us through that thus far. Now, explaining what is not an easy topic to get your head around. Now, the latter part of this discussion is not going to be easy to get your head around either, but it's all quite interesting, so we're going to do our best. Okay, so now Zana's explained some of the things that have changed, the definition of casual employment that's changed as part of the new legislation that's just been passed. And another change that has been made as per this new amendment is that employers must now provide new casual employees with what's called a casual employment information statement when they start. So this is in addition to the Fair Work information statement that they already need to provide to all their employees. Now, hopefully this change will help casual employees better understand their rights and entitlements when it comes to casual conversion. If you're already working casually, then your employer has an obligation to provide you with this statement. If you work for a small business, you should have received this as soon as possible after the 27th of March of this year. And for all other employers, they have until as soon as possible after the 27th of September of this year to provide the statement to their casual employees. Now, if you haven't yet received this statement, but you're interested in what it says, you can find a copy of it on the Fair Work Ombudsman's website, and our lovely comms manager, Amanda, is going to drop a note in the announcements section with the link if you're interested. So now we're going to talk about casual conversion and what that actually means for you as a casual. Now, I want to lay this out for you as much as I can and as simply as I can, so bear with me. First, I'm going to tell you what casual conversion is. And there are 3 key points I want you to remember. Now, when we say casual conversion, it's not being converted to a casual, it's being converted from a casual worker to a permanent worker. Now, after we talk about those 3 key points, then we're going to talk about the exceptions, because lawyers and politicians love their exceptions. Now, here there are 2 main types. There's the reasonable business ground exception and the small business exception. Then, once we've gone through that, I'm going to touch briefly on how the courts can deal with disputes about casual conversions, and then a final note on offsetting entitlements. So, moving on, casual conversion. So, the casual conversion stipulations in the new legislation is by far the largest and most significant change, in that it involves adding a new entitlement to the national employment standards. And this new entitlement gives casual employees a pathway to become a permanent employee, a full-time employee or a part-time employee. And as we were saying, this is known as casual conversion. Now, a quick note for those who may not know what they are: the National Employment Standards, or often abbreviated to the NES or the NES, are minimum employment standards that must be provided to all employees. Modern awards and enterprise agreements must provide conditions that are equal to or better than the National Employment Standards, and they cannot leave the employees worse off. Similarly, if you're on a common law contract, you cannot contract out of your entitlements under the National Employment Standards. Now, I won't go into each of the minimum entitlements because I'm conscious of the time, but if you're interested in them, you can find out more on the Fair Work Ombudsman's website. And again, Amanda is going to drop a link into the announcements section for you. All right, so back to casual conversion. This is now considered a workplace right under the general protection provisions of the Fair Work Act, and it extends to all national system employees, not just employees who are covered by a modern award. The law now states that employers must proactively offer casual employees conversion to a permanent role, full-time or part-time, depending on what hours they have previously worked, if they have been employed for a 12-month period and in the last 6 months of that employment, they have worked a regular pattern of hours on an ongoing basis, and the employee could continue to work this pattern of hours as a part-time or full-time employee without significant adjustment. Now, this offer must be made in writing within 21 days following their 12 months of employment, and it must reflect the hours that they've worked. Employees then have 21 days to accept or reject the offer, and if you don't respond, it's taken as a rejection. Now, employers are not allowed to reduce or vary employees' hours or terminate. And if you think your employer is doing something to affect your right to casual conversion, please give JobWatch a call. Now, as we were talking about those much loved exceptions, so employers are not required to make this offer of casual conversion if there are reasonable business grounds based on facts that are known or reasonably foreseeable to not make that offer. Now, this might include, for example, if the employee's position will cease to exist in the following 12-month period, or the hours of work which the employee is required to work will be significantly reduced. If there will be a significant change in the days or times that the employee's hours of work are required, and the employee cannot make themselves available to work these days and times. And additionally, if making an offer would not comply with the recruitment or selection process required under state or Commonwealth law. However, if the employer has decided not to make an offer, they still need to notify the employee in writing within 21 days of the reasons why they're not being offered, or they think the employee is not entitled to casual conversion. One of the other avenues for exceptions, so that one talks about reasonable business grounds, and the next exception that is explicitly stated in the legislation is if you are a small business. So if you are a business that has 14 or fewer employees, you don't have to proactively offer conversion after 12 months. However, the employees can still request casual conversion. So in that sense, it's very much like the old casual conversion clauses in modern awards and enterprise agreements, where, you know, an employee after a certain amount of time could request casual conversion. So in order to request casual conversion under the new legislation, an employee must satisfy the eligibility criteria discussed earlier. In the sense, they have to be employed for a 12-month period, and the latter 6 months has to show a regular engagement. And additionally, you must have not refused an employer's offer for casual conversion in the past 6 months. The employer must not have given you notice that they have decided not to order conversion based on reasonable business grounds. The employer must not have refused a previous request during the period, and the request has not been made within the 21 days after the employer has made an offer pursuant to that 12-month offer requirement that we talked about previously. Your employer then has 21 days to provide a written response, either accepting or declining your request. Whew, okay, so that's a lot of changes to casual conversion. As a result of this, there is a new avenue that's just been introduced to resolve some disputes about casual conversion. And this is about this. They do this by giving employees an avenue to the Federal Circuit Court via the small claims procedure. And in this particular circumstance, the court will be able to help with disputes about whether A, a casual employee meets the requirements for their employer to make an offer for them to become a permanent employee, whether the employer has reasonable grounds not to make an offer or to refuse a request for casual conversion, whether a casual employee meets the requirements to make a request to their employer for casual conversion. Okay, so prior to this new legislation, there was always an avenue that an employee could take to address a dispute about casual conversion, so long as that casual conversion was a clause in their award or their enterprise agreement. Now that avenue still remains. Okay, you can still activate the dispute resolution clause in your modern award or enterprise agreement and bring it to the attention of the Fair Work Commission. However, that wasn't possible if you didn't have an enterprise agreement or a modern award. So under a newly introduced Section 66M of the Fair Work Act, if you don't have a modern award or an enterprise agreement, you can still bring a dispute to the attention of the Fair Work Commission. And additionally, you can also bring the dispute to the Federal Circuit Court, by way of the small claims procedure. So there are new avenues opening up and wider avenues being created if there is a dispute as to casual conversion. Now we come to the offset of entitlements, which, if anyone has been following the case law around this, is a very, very complex area. Now, when it comes to raising a dispute with regard to your employment status or casual conversion, one of the most common calls that JobWatch receives through the TIS is for underpayment of wages, generally at the end of the employment. Now, the changes to the Fair Work Act now mean that where an employee has been misclassified as a casual, so they've been working for their employer, but their hours have reflected a more permanent engagement, their employer can use the 25% loading that they have paid to the employee as a casual to offset any entitlements that they may owe to the employee upon discovering that they are indeed a permanent employee. So in this scenario, a court must reduce an amount payable to the employee by way of annual leave or personal carers leave or something like that by the amount of casual loading that has been paid to them during that same time. And they can also reduce the claim amount by a proportion of the casual loading as well, where the claim amount is for only some of the entitlements compensated for by the loading. Now, I know that's really confusing to understand, but there will be some examples that Amanda will pop up online for you to have a look at, because the idea of offset confuses many lawyers as well. So if you're sitting there scratching your head, I don't blame you. Now, we will get more clarification as to this when these cases are litigated, because we can't really get a lot of clarification about the application of the legislation itself until someone mounts a test case. So we'll be watching this space with much interest to see how this plays out in the courts. Now, an important date as well to keep in mind, if you're already working casually for an employer that is not a small business employer, is that your employer needs to assess by the 27th of September of this year whether you and other casual employees are eligible to be offered to convert to permanent employment. And if you believe that you're eligible and you haven't heard from your employer by that date, you can make the request in writing yourself, and we would urge you to do that. So we just went through a lot of really legal information about casual conversion, and you, again, would be very confused. So there are some case studies as well that will help to illustrate this, and Amanda has dropped a few case studies into the announcements tab, and we'll also share these on social media over the next few days as well. Okay. Now that we've run through the changes for casuals from the recent IR Omnibus Bill, we're going to run through a number of the questions that we've received in the lead up to this event, which is fantastic. Thank you guys very, very much for putting those questions through. Some we've already covered earlier in this presentation. For example, we received some questions like, in what circumstances can a casual be made permanent? So we won't run through that information again. But yep, again, thank you to everyone who submitted these questions. And don't forget that if you have any other questions to add now, just drop them into the Q&A function. We have some time set aside at the end to answer more of your questions, but I don't know exactly how much, but Amanda will call time when we're coming to the end. Okay, so the first question we've received is, how do the changes to the casual to permanent laws impact those engaged via a recruitment agency / labour hire company? That's a really, really good question. Now, recruitment agencies and labour hire companies are often used interchangeably, but the important question is, with both, who is the actual employer? So normally a recruitment agency is a business that matches people looking for employment with employers, but once the employee's been matched, there's no ongoing involvement in how the person is paid and the work that they do. Whereas a labour hire company provides its own employees to do work for its clients. The clients are often called host employers, where in fact there is no employment relationship there at all. In either case, the new rights and obligations exist between the employer and the employee. So if it's the labour hire company and the worker, then it would, they being the actual employer, the obligations would exist between the labour hire company and the employee. So this would not apply between employees of a labour hire company and the host employer or the labour hire company's clients. Now, another question that we have received is for someone who is working as a casual contractor. Okay, has asked, casual contractor through an agency for the government has asked if they have the right to convert to permanent employment. The first thing we need to consider in this, as per this question, is the use of the term casual contractor. So you're either a casual employee or you're a genuine independent contractor. You can't be both. So if you're a casual employee, the answer is the same as what we said earlier. The new right to convert to permanent employment exists between you and your employer, whether that be the agency or the government department. Assuming that your employer has over 15 employees, or rather 15 or more, you should receive notification by the 27th of September about whether you are eligible to be offered to convert to permanent employment. If you believe that you are eligible, again, and you haven't heard from your employer by that date, you can make the request in writing yourself, as per the information we provided earlier. However, if you are an independent contractor, the conversion provisions do not apply. If you're not sure if you're a casual employee or an independent contractor, and it's a very complex point of law, the best thing to do is to seek tailored legal advice. But, you know, in general, you're more likely to be considered an independent contractor by the law if you provide your own tools and equipment. If you have a greater degree of control over when and how you do your work, that's a big one. The greater the control your boss has, for example, the more likely it is that an employment relationship exists. You invoice for the work that you do. You choose the hours that you work for more than one boss. You contract with more than one principal. You have registered as your own business and have an ABN, and that's an important thing because it's difficult to say you're in business for yourself if you don't have an ABN. Another indication is if your contract says so. A contract can be in writing or it can be verbal. So, you know, both are valid, although with a verbal contract, sometimes it can be more difficult to prove. Another indication is that you're free to get other people to do the work for you. You're free to delegate to others. Another indication is that your pay is based on your output rather than the hours that you work, by the job and not by the hours. It's important to note, though, that not one of these factors is considered determinative. Okay, you have to look at the totality of the relationship. All the factors in the relationship are considered together in determining whether someone is an independent contractor or not. And again, if you're not sure, please seek legal advice on the issue because it could make a lot of difference. Another question that we have received is what happens if your workplace does not comply with these changes? That's another really good question. Now, if you're an employee affected by this or the Fair Work Ombudsman has investigated, so an employee can address this issue or the Fair Work Ombudsman can, you can both apply for orders to the Federal Circuit Court or to the Fair Work Commission to settle a dispute. The individual should always seek initial legal information from JobWatch's telephone information service before they do this, and then probably more tailored legal advice depending on the individual circumstances. So, yeah, there are avenues that you can pursue if your workplace is not complying with the law. Yes, now again, another question is how will the small claims procedure for casual conversion requests work? Will the Federal Circuit Court have the ability in this small claims procedure to order casual employees be converted to permanent employment? Okay, just to clarify, when we talk about the small claims procedure, we're talking about the small claims jurisdiction of the Federal Circuit Court. At the moment, if you are trying to pursue unpaid wages that are under $20,000, you have access to the Federal Circuit Court's small claims jurisdiction. Technically, it is called the small claims procedure, but the idea is that you don't need to be represented. It's quite informal, even though technically it is a court and the judge can make determinations. So with regards to the casual conversion avenue to the small claims jurisdiction, in that jurisdiction, the federal court can make any order it considers appropriate. So including ordering casual employees to be converted to permanent employment by way of a court order. Now, the examples that are given in the note to the new section 548(1)(b) are slightly gentler than this. They talk about they can require an employer to consider whether an offer should be made, or they can prevent an employer from relying on a particular ground to refuse a request. But basically, yes, the federal court can order that a casual employee be made permanent. It's one of the things that they are able to do. Another question is, what happens if you've just requested to convert your casual regular hours to permanent and your employer rejects it? And the only reason given was that there was a clause in the enterprise agreement that was struck out. Okay, so look, if an employee didn't have the right to request conversion under their enterprise agreement, which would have been the instrument that covered their employment, at the time when a request was made, the employer would not have been obliged to respond positively then. They wouldn't have been obliged to allow the employee to convert. However, like we were saying earlier, The new casual conversion provisions are in the National Employment Standards, which can't be undercut by the terms of an enterprise agreement. So if an employer has failed to comply with its obligations in responding to a request made under the National Employment Standards, you can pursue this via the dispute resolution mechanism, via the Federal Circuit, via the Fair Work Commission, and also the enforcement options we listed earlier with regards to the Federal Circuit Court. I've got another question here about how can I check whether I'm getting paid the correct amount. Now, the most important thing about understanding if you're getting paid the right amount is to understand what you're working under, what instrument covers your employment. Is it a modern award? Is it an enterprise agreement? Everybody that works has a common law contract of employment, but some people are covered only by a common law contract of employment and the National Employment Standards as well. However, if you're working under a modern award, you can figure out which one it is by visiting the Fair Work Ombudsman's website, which has something called the PACT. We call it the PACT calculator, but it's actually the pay and conditions tool. It's an online electronic tool which asks you a series of questions about your work to figure out what your award is. If you're working under an enterprise agreement, and this tends to be more common if you're working for a larger company, you can look up your enterprise agreement on the Fair Work Commission's website by typing in the name of your employer, for example, Woolworths or Coles. If you're working under a common law contract, which again, everybody who is working has a common law contract, but if there is an agreement between yourself and your employer, your rate of pay should be noted in the contract. And in these cases, the main thing to note is that your rate of pay and other work conditions should not leave you worse off than the relevant award. So for example, if you have a common law contract that purports to allow you to be paid under award, it's of no effect because a contract can't undercut an award. Okay. Now, Amanda is dropping links now to the PACT calculator and the Fair Work Commission in the announcement tabs because she's magnificent. All right. Now we have a question about superannuation. So do casual employees have the right to be paid super? So under Australia's current superannuation laws, under the Superannuation Guarantee Administration Act, casual staff must receive at least 9.5% superannuation contributions from their employer if they are over 18 and they earn more than $450 per month before tax. If you're under 18, not only do you have to earn more than $450 per month before tax, but you also need to work at least 30 hours per week before you were eligible to receive super. However, there are changes ahead. In last week's federal budget, it was announced that the $450 per month threshold would be removed from the start of the first financial year once the appropriate legislation is approved, assuming it will probably be the 1st of July 2022 if it passes. And the budget papers and the media are reporting this as a win for women who are more likely to work casually or part-time, but there's currently no further information on what this means for those who are under 18 and whether they still need to work at least 30 hours per week. So once the legislation is drafted and made public, we will know more. Now, apparently the 9.5% contribution is scheduled to increase to 10% as well on the 1st of July 2021. And presuming that nothing changes between now and the 30th of June, expect to see a little bit more in your superannuation account on the 1st of July 2020. As far as how you calculate superannuation, when it comes to what the contribution should be, it's based on ordinary time earnings or OTE, and that's comprised of your basic wages, any casual loading, weekend shift loading, and most types of allowances and bonuses. Some things that aren't included in OTE or ordinary time earnings are overtime, reimbursements or expense allowances. So, for example, if you receive a $10 mobile phone allowance each month, that's not included in the ordinary time earnings. So your employer doesn't have to pay superannuation contributions on that. Now, that's a very basic overview, but there are, as you know, there are other items too numerous to name. But if you're curious, hop onto the ATO website because they've got some good fact sheets on there about what constitutes ordinary time earnings. Now, another question is, are there any vital things to look out for in employment contracts, especially for internships, like waiving rights for injury damage, unpaid internships, etc.? Are there lines to draw for unfair, unacceptable employment contracts? Yeah, so that's a really big question, and that could be the topic of its own webinar, but it's a very good question. Very briefly, internships must be genuinely for the benefit of the intern and not involve the normal commercial activities of the business. For example, if the internship was for credit in a course of study, and you can often see this for courses like nursing or medicine, where students have to complete placements in hospitals, or in JobWatch's case, where we have law students completing employment law placements in our organisation for cause credit. If the relationship is in fact one of employment, the employee will have employment entitlements rather, despite a contract saying that they don't. So, you know, regardless of what the contract says, if the relationship is determined to be one of employment, then they do have entitlements. So in general, employment contractual terms that undercut the NES, all modern awards or enterprise agreements, will be ineffective. The Fair Work Act also specifically overrides some types of contractual terms. For example, unreasonable requirements for employees to spend or pay money to their employer. Now, if you are the person who asked this question, or if you know people taking on unpaid internships that aren't part of credit in the course of study, I recommend that you call JobWatch for more tailored legal information.
This is Amanda jumping in. We do have a number of other questions that were submitted during the registration process, but just being mindful of time, we might not have the opportunity to get to them, so we will respond to those individuals directly after this webinar. I do want to address two questions that have been submitted through the live Q&A just during the past hour. And these two questions, Al, are quite similar in nature, so I might actually read them both out to you. The first one is, I have been working for the same business for nearly 4 years and they keep giving me casual contracts for 3, 6 and 12 months. Am I allowed to ask for a permanent contract if I'm still under a casual contract? And then the second question, which is very similar, is I work for a childcare for nearly 4 years and only keep getting given casual contracts for 3 to 6 months. I was told if I work there for longer than 12 months, I would be offered a permanent contract, but it still hasn't happened.
Yeah, they're really good questions, and that's really tricky. So what you'd be looking at here is whether or not you could classify the terms of engagement that you had with your employer as continuous. Okay, now these series of back-to-back casual contracts that the employer is putting you on, again, the idea of a casual contract, an ongoing casual contract, is a bit of a misnomer, because technically, as you know, a casual contract begins at the beginning of the shift and ends at the end of the shift. Okay, you can put somebody on a contract for a specified period of time, but generally speaking, they're going to be permanent part-time or full-time contracts, because one of the ways that you determine the type of contract is whether or not it has a notice clause in it. And casual contracts don't have notice clauses at all, because casuals aren't entitled to notice, nor do they have to give it. So with regards to casual conversion in both those situations, I would argue that your employment has become ongoing. You've been an ongoing employee for, in one case, I would say 4 years. And I'm sorry for the first question, I can't remember exactly how long you had been there. But I would say that those, you know, again, just on a very basic, you know, telling of the question itself, I would say the casual conversion provisions in the Act apply to both of you. So, you know, if your employer was trying to argue that no, they were time-limited casual contracts, coming from the perspective of an employment lawyer, that's kind of a silly argument, because you know, you're either a casual employee or you're a permanent employee. And if you are a casual employee on a time-limited contract, it doesn't really work. So I would say that, yeah, for both of you, I would say that the casual conversion provisions would apply to both. Yeah.
Wonderful, thank you, Al. We haven't had any other live questions come through. So if you're happy to wrap it up, Al, maybe we might actually cover the last question around, is my boss allowed to contact me a lot on my days off and late at night as well? Because I think that's a really important question and one that we sometimes see. through the calls that we receive on our TIS?
Yeah, that's a good question. So look, the answer to that will depend on what's actually set out in your modern award or your EA or enterprise agreement or your contract. Some contracts might specify the mention of an expectation of availability outside of typical work hours, but this is more common for full or part-time staff rather than casual staff. You might see in some awards there's something called an on-call allowance. That can sometimes be applicable to people who work in the care industry, sometimes IT professionals or things like that. But again, that's probably more applicable to people who are permanent or permanent full-time or permanent part-time employees. So typically, as a casual worker, if you're being asked to actually do work outside of your typical work hours, so if you're being asked, for example, to log on remotely from home to, I don't know, process an urgent invoice or send an email, you should be paid for those hours. But if it's just a text message confirming your next shift, for example, you probably wouldn't be paid for that. We should add a note here that if texts or calls of a personal nature, instead of texts or calls that are relating to business, if there are those texts that are being exchanged, you don't have to respond. Okay, but we understand that there is a power imbalance there between an employer and an employee, and if work is precarious, then there might be pressures to be amicable. But it's very important to remember that if you're receiving calls or texts from your employer that are inappropriate, and that inappropriateness might be just that it's way too late, you're in bed, your kids are in bed, it's 11 o'clock at night, then, or, hopefully this doesn't happen, but, really inappropriate stuff, then you should contact us to discuss either bullying or sexual harassment, because unfortunately it does happen quite a lot. Now, it's a bit of a grey area here. So if you're the person that asked this question, I would encourage you to call the JobWatch TIS on 9662 1933 for free and confidential legal information, and our phone consultants can give you more information tailored to your situation. Okay, Amanda, are we all good? All right, so I'm very, very aware that we have given you a lot of information, so don't worry if you've forgotten most of it or you need more information. You can always find information sheets relevant to a lot of the topics I've covered on the JobWatch website. And Amanda should have a slide up there. Yep, beautiful. Now, one final point that I must emphasise, if something bad happens to you at work, God forbid, don't wait to seek help. There are very strict, one could say draconian time limitations on things like filing an unfair dismissal claim with the Fair Work Commission. So you need to do it within 21 days of the dismissal taking effect. Once again, if you need to, call the JobWatch TIS for free and confidential legal information, and our phone consultants can give you the information on what to do next. Now, as a small reminder, we'll be sending out a very quick survey to all webinar participants in the next 24 hours. And it would be really helpful for us if you're able to complete that survey, as your feedback can help us improve all our presentations in the future.
And just a quick note that the survey will only take 2 minutes, so barely any time out of your day.
And Amanda has also asked me to tell you that to remind you to follow us on social media. We're on Facebook, Twitter and LinkedIn. And if you've enjoyed today's webinar and found it useful, please leave us a review on Facebook and Google as well. And look, thank you very much, guys, for coming here and being talked at for an hour. I hope you found this information useful. And I wish you all the very, very best. Thank you from me and Amanda and Zana.